Good day, Crime Talk aficionados. My name is Scott Reich, and this is Crime Talk. I apologize for not having a show up yesterday. I was unable to get one up because I had to go do some of that real-world lawyer stuff. So that means we have a big docket today. Quick preview. First, suddenly, the court in the Lori Vallow Chad Daybell matter suddenly wants to follow the rules regarding sealing of materials. I wonder why that is. The Mar-A-Lago affidavit is released, and, well, there's so many redactions, not really released anything. Letecia Stauch is still not crazy. That former movie producer, yep, he's going to have his case heard at the highest court in New York. An update on the Arkansas beating case. A marriage that gets off to a rocky start. Ghislaine Maxwell wants to stiff her attorneys. A not guilty in Ohio, an update on a terrible child abuse case. The former Uvalde police chief cries racism and says, "Pay me." Paul Pelosi gets his card pulled. And then finally, our dumb criminal of the day. Let's talk about it. All right, everyone, you know the drill. It was a long introduction. But hey, if you haven't done so already, subscribe if you haven't, like if you do, leave me a comment, hit that little bell so you get notifications when we go live or put up new content. And always remember and never forget that you can listen to us on any of your favorite podcasting apps. We've got a big docket, so let's get to it. So let's open the record for August 26, 2022. First, let's talk about Lori Vallow and Chad Daybell. Remember a couple of weeks ago when Lori Hellis filed a motion as an intervener, or just as a regular person, as the judge tries to refer to her as, somebody who wants to see what is being sealed. And just happened to call the court's attention to the fact that they're not following procedures in regards to the sealing of records that apparently are so prejudicial, will simply result in an absolute unfair trial. Well, guess what? Well, now the court and the prosecution is following forward on those procedures. What a coincidence. It's almost as if somebody called them out on it and they said, I guess we now have to follow the law. So the prosecution in Chad Daybell's case has filed a motion to seal that was dated August 25th, as of yesterday. And it states basically that they want to seal the matter, one, in the interest of privacy. The documents during this pendency of this criminal investigation in this best interest of justice, and will preserve the right to a fair trial. The defendant's motion requesting permission to appeal two of the court's orders was filed under seal, and the defendant's motion relates to defendant's prior motions, including motions to disqualify prosecuting attorneys, motions to disqualify out-of-state prosecutor, motion to dismiss special prosecutor, and a motion for disclosure of Rachel Smith's cases, which were previously filed under seal, as well as the state's prior objections in response to the motion. Therefore, Judge, please go ahead and grant the motion because, well, we don't want anybody to know what we're talking about. The public doesn't have a right to know, and we're going to say it's in the public interest, although they can't define how or if it is in the public interest, which goes to the whole point of this stuff. Yes, there are certain things that need to be filed under seal, but motions regarding disqualification of the prosecutors, I cannot think of one. And I think the court has an obligation, as well as everyone else here, to say, what is the basis for this? Bottom line, that's what it comes down to, and they're simply not providing that. And then the court issues an order basically saying that the defendant's moving request permission to appeal two of the court's orders in pursuant to the Idaho rules was filed under seal and relates to the defendant's prior motions, and they list them all again. And guess what? It is hereby granted, ordered, sealed. And then we have something else. The court issues an order, and it says, based upon the parties' request for an ad hoc status conference, ad hoc just simply means as needed, status conference following a hearing on August 16th. So remember the hearing on August 16th? That was the one about the DNA evidence and the protocols and things like that. I think they'd come to a conclusion. But there wasn't anything about the whole defendant's mental health. So when the court says that, after the hearing, they held an on-the-record conversation, that's a lot different than hearing. Now, the court held an on-the-record conversation with all parties. conversation, not a hearing, ladies and gentlemen, a conversation. And it states, including the defendant regarding mental health pursuant to Idaho Code Section 18-210. And you may say, well, what the heck is Idaho Code Section 18-210? Well, let me tell you what it means. This means lack of capacity to understand proceedings, delay of trial. No person who, as a result of mental disease or defects, lacks capacity to understand the proceedings against him or her to assist in his own defense shall be tried, convicted, sentenced, or punished for the commission of an offense so long as such incapacity endures. All right, so they had a conversation about that. Seems to be a pretty big subject. Based upon the previous order entered on September 14th of 2021, and after due consideration of the factors set forth in Idaho Code, or in accordance with the Idaho Rules 32, and finding a likelihood remains that both the state and the defense could be prejudiced by discussing or dissemination of information already sealed, the court finds that a compelling interest is at stake in the need to preserve a fair trial, and no reasonable alternative exists to protect the fundamental rights except to keep the hearing closed and the record of it sealed. Are you kidding me, ladies and gentlemen? If there is an issue regarding competency, why should the public not be entitled to be aware of this information? And the judge, apparently sua sponte, on his own, goes ahead and drafts an order saying that we're going to seal everything here because we're going to do everything in the dark here in Idaho. I've done hearings regarding competency. I've done hearings regarding NGRI, and they're all done in open records. Are you kidding me? What the heck is going on in Idaho? I don't get it. I don't know why they think everything is a big secret out there. It's not. It needs to be made public. Now, I'm pretty certain some other salvos are going to be filed in regards to the unsealing of records, and I think it's coming soon. And the one reason why the court and the prosecution is now suddenly following the rules as it relates to sealing the documents in the public record of cases of matter of public concern, guess what? It's because of Lori Hellis filing her motions. The judge may have denied her standing issues based upon some semantics, but I got a feeling we're going to hear from her again. All right. Next on the docket, the affidavit regarding the Mar-A-Lago search has been released. And frankly, just me, and I'm reading this from a perspective of somebody that's saying, hey, my client is in trouble, and looking at this particular affidavit. You know, one thing you know for sure is magistrate judges are not Title III judges. Title III judges refer to the judges referred to in Title III of the United States Constitution, and they sit basically until their death. Magistrates have to reapply for their job, and I think it's like every 7 years or something along those lines. Okay? And this is why you can see oftentimes why you think, oh, okay, magistrates kind of rubber stamp things. Okay? So here is the issue that I see it. Now, the United States National Archives and Records Administration, NARA, they sent to the United States Department of Justice a referral basically for criminal prosecution. And the NARA referral stated that on January 18th of 2022, in accordance with the Presidential Records Act, NARA received from the office of the former president, Donald Trump, hereinafter the F. POTUS, via representative, 15 boxes of records, including the 15 boxes which had been transported from the POTUS property at the Mar-A-Lago address, referred to as the premises, were reported by NARA to contain, among other things, highly classified documents intermingled with other records. After an initial review of the NARA referral, the Federal Bureau of Investigation opened a criminal investigation to, among other things, determine how the documents with classification markings and records were removed from the White House. Now, I've said this before. Somehow I don't think the President of the United States, as he's leaving, is packing up his desk. I think they have people that do that for him. Needless to say, we continue. And they want to know how these records came to be stored at the premises, a.k.a. Mar-A-Lago, and whether the storage location at the premises were an authorized location for the storage of classified information. Determine whether any additional information, documents, records may have been stored in an unauthorized location at the premises or an unknown location, and whether they remain in any such location, and to identify any person who may have been removed or retained classified information without the authorization and or authorized space. Then the FBI investigation has established the documents bearing classification markings, which appear to contain national defense information, were among the other materials contained in the 15 boxes and were stored at the premises in an unauthorized location. Then we have some big old redaction, right? All the good stuff. Then it says further, there's probable cause to believe that in addition to the documents that contain classified NDI or that the presidential records subject to record retention requirements currently remain at the premises. There is also probable cause to believe that evidence of obstruction will be found at the office. Then it goes on and says, I am a special agent with the FBI assigned to the Washington field office. The Washington field office that has never been involved in any sort of thing political. Now, during this time, I've received training at the FBI Academy located at Quantico, Virginia. Yeah, they borrow the spot from the Marines. Just saying. We used to always see the FBI guys running around in their little sweatpants, and we were out there in boots and utes running along. They're not as tough as everybody thinks they are. Anyway, and he has specific training in counterintelligence and espionage. Now, the next couple of pages go on based upon why they think it is, and they say they provide the statutory authority and definitions, right? The stuff that's not redacted is stuff that is basically definitions of what they believe is some of the relevant law. And then they talk about pursuant to executive order, classified information contained, or automated information systems includes networks, a whole lot of definitions. Then they describe what presidential records are. And then they go on to say probable cause that on February 9th, the special agent in charge of NARA's office of the Inspector General sent the NARA referral to the email to the DOJ. The NARA referral stated that according to NARA's White House liaison director, a preliminary review of the 15 boxes indicated that it contained newspapers, magazines, printed news articles, photos, miscellaneous printouts, notes, presidential correspondence, personal and post-presidential records, and a lot of confidential records. Of most significant concern was that the highly classified records were unfolded, intermixed, and with other records otherwise improperly identified. On February 18th of 2022, the archivist of the United States Chief Administrator for the NARA states that the letter to Congress's Committee on Oversight and Reform Chairwoman, the Honorable Carol B. Maloney, NARA's had ongoing communication with the representatives of former President Trump through 2021, which resulted in the transfer of 15 boxes to NARA in January of 2022. NARA has identified items marked as classified national security information with the boxes. The letter also stated that because NARA identified classified information in the boxes, NARA staff has been in communication with the Department of Justice. Ooh. The letter was made public and available to the following uniform resources locator, and they list a URL. On February 18, 2022, the same day, the Save America Political Action Committee posted the following statements on behalf of the former POTUS. The National Archives did not find anything. They were given upon request. Presidential records in an ordinary and routine process ensure the preservation of my legacy in accordance with the Presidential Records Act, and then they provide an image of that. And then guess what? Redaction. Boxes containing documents were transported from the White House to Mar-A-Lago. And according to a CBS Miami article titled Moving Truck Spotted at Mar-A-Lago, published Monday, January 18, 2021, at least 2 moving trucks were observed as the premises of January 18, 2021. Apparently from a newspaper article. More redactions. On about May 6th, NARA made a request for the missing PRA records and continued to make requests until approximately late December of 2021, when NARA was informed 12 boxes were found and ready for retrieval at the premises. Redaction. 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 The 15 boxes provided to the NARA contain classified information. From May 16th through 18th, 2022, FBI agents conducted preliminary review of the 15 boxes provided to NARA and identified documents with classification markings in 14 of the 15 boxes. A preliminary triage of the documents with classification markings revealed the following approximate numbers: 184 unique documents bearing classification markings, including 67 documents marked as confidential, 92 documents marked as secret, and 25 documents marked as top secret. Further, the FBI agents observed markings reflecting the following compartment dissemination controls: HCS, FISA, ORCON, NORFCON, and SI. Based upon my training experience, I know these documents classified at these levels typically contain NDI. Several of these documents also contain what appear to be former POTUS's handwritten notes. Like he read this stuff, he was given stuff and he read it. Imagine such a thing. And then it's redacted. And then it's redacted. And then there's a statement that said, in his second such letter, which is attached as Exhibit 1, the former POTUS's counsel, I asked DOJ to consider a few principles, which include the former POTUS's counsel claimed that the president has an absolute authority to declassify the documents. In this letter, the former POTUS counsel requested, among other things, that the DOJ provide this letter to any judicial officer who is asked to rule on any motion pertaining to the investigation or any application made in connection of that. Then he states, I'm aware of an article published in Breitbart on May 5th, 2022, and he gives the links, which states that Kash Patel, who is described as a former top POTUS administrative official, characterized as misleading reports in other news organizations, that NARA had found classified materials among the former presidents provided to NARA from Mar-A-Lago. Patel alleged that such reports were misleading because the former POTUS had declassified the materials at issue. Then it goes redacted, redacted. Then we get here. It says, on June 8th, the DOJ counsel sent POTUS counsel a letter which reiterated the premises are not authorized to store classified information and requested the preservation of the storage room, and the boxes had been moved from the White House to the premises. Specifically, the letter states, as I previously indicated to you, Mar-A-Lago does not include a secure location authorized for the storage of such information. As such, it appears that since the time the classification of documents, redaction, were removed from the secure facilities, the White House moved to Mar-A-Lago on around January 20th, 2021, they have not been handled in appropriate manners or stored in the appropriate location. Accordingly, we asked that the room Mar-A-Lago, where the documents had been stored and secured, and that all boxes were removed from the White House Mar-A-Lago, be preserved in a room that are in their current condition until further notice. Store them. Redaction. 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 Based upon this investigation, I believe that the storage room, POTUS's residence, and other spaces within the premises are not currently authorized location for the storage of classified information or NDI. Similarly, based upon this investigation, I do not believe that any space within the premises has been authorized for the storage classification, at least since the end of POTUS's presidential administration. Redaction. Conclusion. Based on the foregoing, I submit probable cause exists to believe that the evidence, contraband, fruits of a crime, or other items illegally possessed in violation of Section 18, Section 793, subparagraph E, 2071, or paragraph 1519 will be found at the premises. I further submit that the affidavit supports probable cause for a warrant search and the premises described, and that they request sealing, and then they say, oh, but we're going to come up with a way to do this, and then they block out the special agent who requested that, which I don't get. If you're the lead agent, man, this is the case of the century, right? You're raiding the former president's house. You should go check that out. But here's, I think, an interesting little letter. And this is the letter that the affiant wrote in the court. And this states the position. And this makes one think that instead of going to execute a search warrant, they could have gone and filed for a declaratory judgment, which is basically saying, hey, Judge, let us know how we need to rule on this. Can this action take place or not? Which I guess is probably why Merrick Garland said he pondered this for 20 or this. And I guess this is why it took Merrick Garland 2 weeks to make this decision with that kind of decisiveness. My goodness, got to know we're all in good hands now, right? Anyway, this is a letter from the former president's counsel handling this, and it is a letter to Jay Bratt, Chief Counterintelligence and Export Control Section. It says, Dear Jay, I write on behalf of President Donald J. Trump regarding the above referenced matter. Public trust in the government is low. At such times, adherence to the rules and long-standing policies is essential. President Donald J. Trump is a leader of the Republican Party. The Department of Justice, as part of the executive branch, is under the control of a president from the opposite party. It is critical, given that dynamic, that every effort is made to ensure actions by the Department of Justice that may touch upon the former president or his close associates does not involve politics. There have been public reports about an investigation by DOJ into presidential records purportedly marked as classified among materials that were once in the White House and unknowingly included among the boxes brought to Mar-A-Lago by the movers. It is important to emphasize that when a request was made for the documents by the National Archives and Records Administration, President Trump readily and voluntarily agreed to their transfer to NARA. The communications regarding the transfer of boxes to NARA were friendly, open, and straightforward. President Trump voluntarily ordered that the boxes be provided to NARA. No legal objection was asserted about the transfer. No concerns were raised about the contents of the boxes. It was a voluntary and open process. Unfortunately, the good faith demonstrated by the President Trump was not matched once the boxes arrived at NARA. Leaked information, and once DOJ got involved, the leaks continued. Leaks about any investigation are concerning. Leaks about an investigation that involved the residence of the former president, who is still active on the national political scene, are particularly troubling. It is important to note a few bedrock principles. 1. A president has absolute authority to declassify documents. Under the United States Constitution, the president is vested in the highest level of authority when it comes to classification and declassification of documents. C. United States Constitution, Article 2, Section 2. The president is Commander-in-Chief of the Army and Navy of the United States. His constitutionally based authority regarding the classification and declassification of documents is unfettered. C. Navy v. Egan, 484 U.S. 518, 1988. Which stands for the proposition that the president's authority to classify and control access to information bearing on national security flows primarily from his constitutional investment of power in the president and exists quite apart from any explicit congressional act. 2. Presidential actions involving classified documents are not subject to criminal sanction. Any attempt to impose criminal liability on a president or former president that involves his actions with respect to documents marked classified would implicate grave constitutional separation of power issues. Beyond that, the primary criminal statute that governs the unauthorized removal and retention of classified documents and materials does not apply to the president. That statute provides in pertinent part as follows. Whoever, being an officer, employee, contractor, or consultant of the United States, and by virtue of his office, employment, position, or contract, becomes possessed of documents or materials containing classified information of the United States, knowingly removes such documents or materials without authority and with intent to retain such documents or materials at an unauthorized location, shall be fined under this title and imprisoned for not more than more. They note, 18 United States Code, Section 1924A. An element of the offense, which the government must prove beyond a reasonable doubt, is that the accused is an officer, employee, contractor, or consultant of the United States. The president is none of these. An officer of the United States can only be appointed by the president, by and with the advice and consent of the Senate, or by a court of law, or a head of the department. A person who does not derive positions from the source is not an officer of the United States in the sense of the Constitution. Thus, the statute doesn't apply to the president. Third, DOJ must be insulated from political influence. According to the Inspector General of the DOJ, one of the top challenges facing the department is the public perception that the Department of Justice is influenced by politics. The report found that one important strategy that can build public trust in the department is to ensure adherence to policies and procedures designed to protect DOJ from accusations of political influence or partial application of the law. We request that the DOJ adhere to longstanding policies and procedures regarding communications between the Department of Justice and the White House regarding pending investigations. And the DOJ must be candid with judges and present exculpatory evidence, which makes you think there'd been threats of this whole thing all along as far as a raid and investigations. Longstanding DOJ policy requires that DOJ attorneys be candid in representations made to judges. Pursuant to these policies, we request that DOJ provide this letter to any judicial officer who is asked to rule on any motion pertaining to this investigation or an application made in connection with any investigative request concerning this investigation. The official policy of the DOJ further requires that the prosecutor present exculpatory evidence to a grand jury. Pursuant to the policy, we request that the DOJ provide this letter to any grand jury considering evidence in connection with this matter, or any grand jury asked to issue a subpoena for leniency or documents in connection with this matter. So what does that really mean? Well, obviously it sounds like there have been some threats that they were going to issue a search warrant. I'm not exactly sure what happened because, well, all the redactions. I've read to you almost all of it. Remember, some people are like, oh, Scott, you're anti-Trump. Oh, Scott, you're pro-Trump. No, let's take a look at it. There's documents that were there. According to the Trump's attorney, they were sent there by the movers. Like I said, use your common sense. You think the president on his way out is going to be going through his desk all by himself? Don't think so. I think they have people that do that for you. They pile the things up, they send them out. Were documents found in the original 15? Sounds like it, but they were turned back over. But they said they think there's more. It's all redacted as to why they think there should be more documents there that should be located. So the point is, a little unclear as to why the judge authorized. I guess you could say, sure, well, we found documents in the first 15 boxes, but then you got the attorneys for the former president saying that, hey, you need to look at this and the president can declassify this. In all honesty, I think that's a little bit above a magistrate's pay grade, so to speak. That's something for a Title III judge to take a look at. Is there probable cause? Probably razor thin to get them there. Could this case be proven beyond a reasonable doubt? Not based upon what I've seen. Prove that the president knew that they were there when they were removed. And apparently there's communications between lawyers, and lawyers are doing what lawyers do. So I don't know. The whole argument about declassification, I'm not really sure. But like I said, I'm not sure that's a job for the magistrate to do. That seems like something, a particular legal question regarding constitutional authority should be heard before a Title III judge. Anyway, I know they went long. Sorry to have to read it, but I wanted to be as fair as possible to both sides, you know, the Department of Justice and the former president. And we read it. And you also see what was redacted. Why is it redacted? Oh, I know they're going to say it's because, you know, it's going to involve processes and procedures and ongoing investigations and everything. No. Everybody who's involved knows if they're under investigation. That's because they think the American people are too stupid to be able to figure out for themselves what's taking place. Bottom line. Anyway, you all decide. I'm thinking probably at some point 9 people that we call justices of the Supreme Court will ultimately decide this ruling as to who is right. All right, next on the record, Letecia Stauch. Remember, She's accused of killing her stepson, Gannon Stauch, who was reported missing back in January 27th of 2020. A few months later, Stauch was arrested for first-degree murder before authorities found Gannon's body in Florida. Now, Stauch initially pled not guilty, but later changed her plea to not guilty by reason of insanity. And as you may recall, police arrested her on March 2nd of 2020 in Myrtle Beach, South Carolina. They found Gannon's body in Pace, Florida on March 18th. And since March 2020, Stauch has been held in the El Paso County Jail, where she faces a bunch of charges, obviously including first-degree murder, and she's been waiting trial now there for over 2 years. Well, because of her delay. In September of 2020, the state psychiatrist told the court Stauch is competent enough to stand trial, but her attorneys asked for a second opinion. A year after her stepson was reported missing, Stauch was found competent to stand trial again. Then in September of 2021, Judge Werner determined that there was enough evidence against Stauch to proceed to trial. That was at the preliminary hearing. And Stauch initially pled not guilty in November of 2021. And right after her attorney stated it is likely that they are going to introduce evidence about Stauch's mental condition after the disappearance of Gannon, but it wasn't really an insanity plea. Well, guess what? The judge treated it as such, and in February, Stauch actually changed her plea to not guilty by reason of insanity, and her defense lawyers filed a motion to waive a jury trial. Now, when Stauch changed her plea back in February, it required the state to conduct yet another mental health evaluation, and Judge Werner said he would not make a ruling on that motion to waive the jury trial without a report on her mental status. Now, since a third evaluation was ordered, there have been a number of delays in getting the report from the state doctors to the court. Not unusual. They are really understaffed. Well, in April, Judge Werner said doctors from the state hospital needed more records that Stauch told them about, records that were in South Carolina where she used to live, and her defense attorney had to fly there to get the original records. Now, the original plan was to have the report done by the end of May, and the results of Stauch's state mental evaluation were scheduled for June 9th. However, the court said it had not received any reports and could not move forward until they did. As a result, Stauch's case was postponed until July 28th with the possibility that the trial could begin as of next year. Then on July 28th, the court still hadn't received any reports, and the court still had nothing in their possession. Well, the report finally arrived. Letecia Stauch appeared in court Thursday afternoon after results of the state mental health evaluation to determine her sanity were provided to the judge. Not surprisingly, the doctors found that she is not suffering from any mental disease or defect that would basically impair her to the state where she could not determine right from wrong. And guess what? Now the defense says, well, we don't like that evaluation. We want another one. We want to challenge it. But no one's really sure what they're doing down there, apparently, as it relates to the new statute that came in. I wouldn't say everybody. The defense has challenged it. They've read the statute for sure. But the judge says, well, I'm sure not sure. So let's set the matter for another court date in September sometime, and we'll get some more clarity on the whole legal issue at hand. I mean, did anybody think the defense wasn't going to challenge it? Well, the judge did also say, hey, if the defense has a second evaluation, it's going to be subject to audio and video recordings, because that's the law, and it must be provided to the prosecution, as anything that she says in the evaluation can be used against her at trial. The defense told the court that the psychiatrist that they want to use is from out of state, but hopes to have the results within 30 days of conducting a second evaluation. So the judge plans to research the statute, and needless to say, everything is stayed until that time. Now, one of the reasons the judge brought this up apparently is that there's already been extended delays in setting a trial date. The mental health evaluation was supposed to be available to the court back in June, and when it wasn't, it got pushed to the 28th of July, and it just keeps going on and on and on. So what does that mean? Not trying to criticize, it just depends. But if I was going to go an NGRI, which I did probably in the last year or so, we got the evaluation from our doctor who said NGRI. Then the state doctors looked at it and said, yeah, NGRI. I'm not sure why the defense didn't go there first. If you don't have an expert that's going to say that, when you ask for that, it's very difficult to get somebody from the state mental hospital to say NGRI. Just saying. Next, the New York State Court of Appeals has granted an appeal to disgraced movie mogul, that's right, that guy named Harvey, and we'll hear arguments on whether he deserves a new trial. As you recall, Mr. Harvey was convicted of sexual assault and sentenced to 23 years in prison. His appeals were rejected, and the 5-judge panel unanimously upheld the trial court's ruling. But now Chief Judge Janet DeForey made the decision to grant the appeal before the entire state court of appeals. The court could uphold the conviction, reverse it, and obviously order a new trial. Obviously, the big issues are everybody else that's not charged. 404B evidence, not really the good way to get a conviction. Can you say Bill Cosby? As you may recall, Bill Cosby's case, although in a different state, Pennsylvania, trial court said it was okay. Appellate court said it was okay. The mid-level court said it was okay. Supreme Court said, no, you can't do that. Are we going to have the same thing for that guy named Harvey? We'll have to wait and see. But in the meantime, he is still in jail in Los Angeles, waiting for his upcoming trial date on October 7th for very similar charges. Little Arkansas cop beating update. The woman who took the video of the 3 police officers beating a man at a gas station has firmly refuted law enforcement's claim that the man who got beat up started the violence while being arrested. She apparently has told the FBI investigators that at no point did she see Randall Worcester attack any officer before the horror, in her words, unfolded. Now, while the woman does not wish to be identified, her sister, Naomi Johnson, states that her sibling's account directly contradicts the police reports, and obviously the police allege Worcester pushed a deputy to the ground and punched his head before being savagely beaten by all 3 officers. Her testimony to federal agents also conflicts with statements by the Crawford County Sheriff, Jim DeMonte, and a lawyer for 2 of the police officers. Now, the woman filmed that video with a friend as the pair sat in their car at the County Express gas station on Sunday. Clearly, we have conflicting accounts here, ladies and gentlemen. What happened? Video doesn't appear from body cams, so just another reason why all police officers should wear body cams. Hell, I'd slap it on all government workers so we can see what the heck they do all day and how they're engaging with the public. Just saying. Hey, here's a good story. Kind of lighten up the mood today, right? Marriage getting off to a little bit of a rocky start. A newlyweds honeymoon took a turn after a man allegedly responded to an ad for sex and was arrested during a sting operation. It's alleged that on Thursday, August 25th, the sheriff spoke at a press conference and announced that 176 people had been arrested since April in a wide-ranging undercover operation targeting who went looking to commit illegal acts of prostitution, some of them with minors. Now, during the press conference, the sheriff mentioned a few cases that stuck out to him, the most including that of 34-year-old Paul Tervosky. Now, Mr. Tervosky reportedly got married on July 15th and was on his honeymoon in Tampa. That same day, while his wife was asleep, he allegedly responded to an ad for sex that an undercover agent had placed, and Tervosky allegedly went to the designated hotel to buy sex and was arrested. I wonder how long that marriage lasted. Well, the sheriff doesn't know either, but I'm guessing not too long. Certainly got off to a rocky start. It reminds me of a situation I had years ago where, let's just say, an executive of a pretty big company hired me for something that maybe her husband had allegedly been accused of doing, an alleged prostitution ring. And I remember her asking one question as we waited there in court on a Saturday or Sunday morning. Is there anything that we could do to get the car seat released from the car? Because they seize the car in those type of situations. And the car seat was in the back seat. Oh, could you imagine? Could you imagine that ride home? Oh my gosh, no. Ghislaine Maxwell. We know she was kind of responsible for that guy named Jeff and keeping things going for him. Well, now, guess what? Ghislaine Maxwell wants to stiff her attorneys. Now, the Denver-based Haddon Morgan and Foreman has sued Maxwell, her brother, Kevin Maxwell, and her husband, Scott Borgenson, in a lawsuit filed in Denver District Court. Now, according to the 18-page complaint, the firm was promised but never paid over $887,000 owed to them after the defendant was arrested in July of 2020. The firm contends that Kevin Maxwell was placed in charge of the monetary arrangements, including paying criminal defense fees by his sister after she was indicted and taken into federal custody. Now, during that representation, the firm alleges that Kevin Maxwell failed to pay the compounding legal bills up to and during her trial in downtown Manhattan federal court. Additionally, according to the complaint, as Ghislaine Maxwell remained incarcerated in a federal prison in nearby Brooklyn, her brother insisted the law firm continue working on her appeal, which they did at least for a little bit. The complaint alleges that Kevin Maxwell would coordinate the financial aspects of her defense, including paying Haddon Morgan Foreman's attorney's fees and all costs advanced by the firm. Now, two of the Haddon Morgan attorneys, Laura Meninger and Jeff Pagliuca, represented the woman who had allegedly, or been convicted now, helped facilitate Jeffrey Epstein's decades-long sex trafficking empire during her criminal case. Now, the law firm had previously represented her in Epstein's related civil matters prior to the criminal charges, and the legal relationship flowed from there. Now, the firm continued to represent Ghislaine Maxwell well through her sentencing into June. She is also represented by attorneys Bobby Stierheim and Christian Everdahl, both of whom practice exclusively in New York. The money problems alleged began early on. Miss Maxwell's willingness and ability to meet her financial obligations became an issue in early of August 2020, the lawsuit alleges, and Haddon Morgan Foreman told Kevin Maxwell they could no longer represent the sister. 2 days after receiving that notification, however, Mr. Maxwell reached an agreement with the firm saying that he would personally guarantee and agree to maintain a $100,000 balance in the firm's trust account. That retainer became exhausted by November of 2020, according to the firm, and by early 2021, the client owed nearly $150,000. At that point, the defendant's brother stepped in. Now, to keep Haddon Morgan Foreman from withdrawing, Mr. Maxwell made a handful of sporadic payments, according to the complaint, and despite his promises, however, he never brought Miss Maxwell's account current, let alone refreshed the evergreen retainer. In light of Mr. Maxwell's past failures in honoring the commitment, Haddon Morgan Foreman required a trial retainer of $1 million to cover anticipated fees and costs. And they also allege that Haddon Morgan Foreman shareholders advised the defendant's brother the month before her trial the law firm could not continue working on the case. Trial occurred in December of 2021, and she was convicted near the end of the month on 5 of the 6 federal charges, including, obviously, the most significant, sex trafficking. Still, the representation continued. When repeatedly pressed to pay, Mr. Maxwell eventually allegedly pinned the blame on his sister's husband, and according to the lawsuit, the brother claimed Borgenson controlled Miss Maxwell's money and was responsible for delaying payments to the firm. The complaint further alleges that Borgenson is attempting to shield his wife's assets from creditors through the use of real estate-focused LLCs. Okay, a couple things, full disclosure. I know the attorneys at Haddon Morgan Foreman, a very, very fine firm. You know, Haddon Morgan Foreman represented the likes of John Benet's parents, Kobe Bryant, and more than I can possibly think of. And they're good. I know both of those attorneys, Jeff Pagliuca as well as Laura Meninger. I know Laura Meninger. I had her actually work on an unrelated business matter on a case a while back. She's a great attorney. I told her she should come on CrimeTalk, and it would be great. Obviously, we can't talk about the whole Ghislaine Maxwell case, but she has a very interesting career, which she should like. But one thing the Maxwells and the husband of Ghislaine Maxwell needs to consider is oftentimes attorneys can use what they learned in the course of their representation when it comes to suing the client. So, for example, if the husband is in fact hiding assets, that could open up an ugly, ugly nest of worms. Just saying, could get ugly. And I probably would ask if I saw Laura or Jeff, how'd you guys let it go so far? Don't get me wrong. We've all been there. You think, it's going to be the case. It's going to pay. It's going to pay. It's going to pay. They're going to pay. They've always paid. They're going to come through. And then they stiff you. That's why lawyers get retainers. Okay. Big retainers. And just me, I would have moved to withdraw. I don't care. As somebody taught me a long time ago, It's better to have not done the work and not got paid than to have done the work and not got paid. There's your racism for the day. A not guilty in Ohio. Jurors in Ohio needed just under 3 hours of deliberations to find Matthew Moore not guilty of murdering his wife, Emily Noble. Prosecutors had accused Mr. Moore of strangling Noble to death on the night of her birthday, May 24th of 2020. Now, Noble was found the following September 16th, hanging from a tree in the woods near her home. Authorities said that Moore put the victim there. A jury of his peers, however, found Mr. Moore not guilty on Friday. Next, let's talk Uvalde. What we are clear of is that the now former Uvalde School District Police Chief, Pete Arredondo, well, he failed in his job miserably. But in typical government official fashion, he did nothing wrong. It's not my fault, and pay me to go away. That's right. No, former chief, you had one job, to protect the kids and the staff. You failed. When that moment came to protect the kids, it was your job, and you were unprepared. And that's why the Texas School Board on Wednesday fired the now former police chief 3 months to the day after the gunman killed 19 fourth graders and 2 teachers at the school under his purview. Former Chief Arredondo has been widely criticized for his response in the shooting, which dozens of police officers stood by for more than an hour while 18-year-old shooter was inside unlocked classrooms with these students and teachers. We'll just leave it at that. What else can you say? Good riddance. Next on the docket, Paul Pelosi gets his card pulled. The California Highway Patrol 1199 Foundation, the Colorado Highway Patrol decision to rescind Paul Pelosi's membership comes just 2 days after he pled guilty to DUI charged over the May 28th crash in Napa. Now, after evaluating the events that led to Mr. Pelosi's arrest and conviction, we're revoking Mr. Pelosi's lifetime membership to the California Highway Patrol 11-99 Foundation, effective immediately, the group said in a statement. The group said they'll refund whatever Mr. Pelosi had donated once all of the items are returned, which he received as far as his joining when he became a member. Now, we discussed this last Tuesday night on our live show. You know, it's completely plausible that Mr. Pelosi, while pulling out his license, I'm not trying, if you watch the video, he wasn't, just happened to pull out his, California Highway Patrol Fraternal Order of Police card to get a little professional courtesy. And this just shows this is the epitome of classic political class entitlement. The rules don't apply to me. Hey, don't you know who I am? I'm someone big and important. Help me out here and I can help you out someday. Did I tell you who my wife is? Yeah, that's right. Classic political class entitlement. That's what they thought. He thought he was going to be able to get out of it. And it's not the first time something like that's happened because they've been doing it all their life. Don't worry, Paul. You can't drive. You can stay home and trade some stocks. Next on the docket. Now, you may not remember the story that broke back on New Year's Day, December of 2021, but a family sat down at a Mrs. Potato Head restaurant in Orlando. But the boy at the table didn't order any food. And the family said that the boy would eat dinner at home, but the waitress noticed that the boy had bruises around his face and arms. The waitress observed some big scratches between his eyebrows and bruises on the side of his eye as she went about her business. She felt that something was wrong. She wrote a sign asking him if he needed help. And this is when he nodded yes, and then she conferred with her manager, who called the police. Now, in an audio that was released on that case back then, we brought it to you, the waitress, Miss Vallow, said, "I'm super concerned and I don't know what to do. Can you give me some advice what I can do?" Well, the boy, she stated, had bruises and was not eating, and all the others were eating. When the officers arrived on the scene, they interviewed the parents and the child, who was said to have winced in pain when asked to roll up the sleeves of his sweatshirt, revealing bruises on his arms. Well, the man, the guy who was acting as the stepdad, Timothy Lee Wilson, was convicted in June of charges of aggravated child abuse with a weapon, child neglect, and false imprisonment. And guess what? He got what was coming to him when he was sentenced the other day. Now, the Orlando judge handed Mr. Wilson the maximum sentence for each charge, amounting to 4 life sentences. Now, Judge Wayne C. Wooten said during sentencing, quote, "You have utterly failed, not only in the role of a parent, but simply in the role of human being. For those reasons, I'm going to impose the sentence that the law allows me to impose, although candidly, in many ways, I feel like it is short of what you thoroughly and richly deserve." Well said, Judge. Sometimes people just need to hear the truth. And that person failed, not only as a stepfather, but as a human being. Okay? Society is judged on how we will treat our children. And the bottom line is you protect them. Parents protect their kids. They don't beat them themselves. Well, the biological mother of the boy, Kristen Swan, said she knew the abuse was taking place and also faced neglect charges. And during a hearing last week, a judge accepted her plea, and she has scheduled sentencing for September 16th. The boy has been reunited with his biological father. And yes, finally today, I know it's been a long show, the dumb criminal of the day. Not long in the sense of boring, but long with a sense of lots of information for you today. Well, the Cleveland Police Department arrested 2 women accused of burglarizing a home in Pawnee County. And according to police officers, they arrested Shelley Crane and Lori Bailey. Police say both women have a criminal history, and one of them was wearing an ankle monitor after getting released on bond for another case. So obviously you see how well pretrial release works. Crane and Bailey are in the Pawnee County Jail on multiple theft and stolen property charges. And it probably had GPS on it as well, which is even better, right? So it puts them right at the scene. Kind of takes away that whole identity thing, doesn't it? That's just dumb. Don't commit crime personally. Don't commit crime. But certainly don't commit crime when you're on bond on another case where you've been accused of committing crime. All right. That's all we have for you today.